Audacity. Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass and Chris Hallett. How are you, Kirk?
Doing great. How are you doing, brother?
I'm great. I'm good.
Welcome, folks, to Law for Dummies. And I just want to put this out there again. This is not meant to be a derogatory term. Dummies, as in, like, you know, the crash test dummies. That they're without knowledge. So it's not meant to be a derogatory term. This is just the name of the show. There's tons of books out there called For Dummies, and that's where I got it from. So originally where it actually came from was Randall Stone, after talking to him for 3.5 hours on the phone and explaining to him law stuff that he had never heard before, anybody ever say it before. And he's like, man, you explain it in a way that grandma can understand it. So that's where we came up with Law for Dummies. So again, not to be a derogatory term or anything. It's just what it is. It's not, you know, we're all dummies here. There's definitely some of us that are lacking more knowledge than others, but we all don't know everything. So, which is why we depend on other people. And one reason I want to put out there that we are actually looking for knowledgeable people on the law, people that are actually interested in learning the law, that have the capability of grasping this stuff with ease, so that we can start getting more people out there doing the same thing I'm doing, the same thing Chris is doing, educating the people. We need to get local. We need people like myself and like Chris Hallett in your local area that you can go to and say, hey, what does the law say here? What does the law say there? And that you can deal with someone face to face. That's what I'm starting to do. I'm getting with my representatives, candidate elects. You know, I'm going to start educating these people on what the law actually says, which is what I'm doing here tonight. And so another thing is we're going to split how we do things. I'm going back with my original vision of educating the people on what the law actually says. You know, it's the rule of law. It says what it says, and it doesn't say what it doesn't say. And then Wednesdays, we're going to do a call-in show. So somewhere throughout the show here, Ted's going to put in some pictures and stuff and kind of give you an idea what that'll look like. He's working on that in the background as we speak. Oh yeah, Ted, can you make me the host of the Zoom here so I can add callers if need be? I know I have one sitting there waiting, but not really going to be a call-in show on Mondays. That's going to be Wednesdays. Wednesdays are going to be designated as the call-in show night. So Monday nights will be my original vision, which is education, what the law actually says. And if you have a question regarding the subject matter of what we're talking about and need me to further explain it or Chris to further explain it, that's what we're looking for when we're talking about accepting phone calls. And if you have a question, this isn't story time. I don't want to hear about your case. If you have a legitimate question based on what we're actually discussing here, you know, at this show pertaining to what we just talked about, please feel free to call in and ask your question. But Mondays are going to be strictly just education, and Wednesdays are going to be the call-in show. So it's kind of hard to do both at the same time when I'm trying to educate you on what the law says. And again, law. not statutes, rules, regulations, rules of procedure, none of that stuff. That's not what I'm here to teach you. I'm here to teach you what the law says, the rule of law, what the law actually says. Like Jeff Sessions says, it says what it says and it means what it means. If you don't understand what it means, get yourself a book. This is Black's Law Dictionary, 6th edition. My Black's Law 9th edition sitting right over there. Chris has got his 10th edition. 10th edition is the latest edition, but and another thing is our state, my state puts out the law, which is right here, the Secretary of the State, Idaho Constitution, Declaration of Independence, and the Constitution for the United States, an Idaho Constitution. So this is something that you can, hit your representatives up and find out where you can get a copy of this stuff, because I don't know, Idaho puts it out every year. So I don't see why other states wouldn't be doing the same.
For Floridians, you go to myflorida.com and you can click on Floridian. You can click on in the search bar and search that document for Florida, the one you just posted for Idaho. That's where I actually found mine.
It's amazing that what this stuff says. If you just read it, that's the problem is I see in this country is nobody wants to take the time to read this stuff. So that's what I'm doing. I'm trying to read it to you. Declaration of Independence says right here, we hold these truths to be self-evident. Well, if our rights are supposed to be self-evident in July 4th of 1776, why are we having such a problem here in 2017 not understanding self-evident rights? I mean, this is supposed to be common law sense. Chris?
Well, and that's just it. And one of the problems that people run into is they confuse what the law says with what the procedure says. You kind of trip over that. Well, in court, it says, you have to do this, 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 and this. Well, that's true. That's the rules of the court. That's not what we're here to talk about. What we're here to talk about is the law. So when you're talking about how the rules of the court, same thing. You can download the PDF and read that till you're blue in the face. It's the exact same process in learning the rules of the court as it is learning the law. But you can't apply the law in court if you don't know what the law says and how to claim those rights, which is why we do this, because this is the first step
right
before you cross the threshold of the courtroom door. So just to kind of put that into perspective, Kirk, I'm sure you probably want to add something there.
Yeah, so there's a thing called judicial notice. Okay, this is why it's nice to have your own book, because under judicial notice, you're supposed to have it certified. But if you have the book, you can pop open the book and go, all right, here's libel. Just happen to open it right to that. A method of defamation expressed by print, writing, pictures, or signs. That's libel. Well, now you know what libel is. But let's get into a couple of terms here that I'd like to put out there so we understand. And what understand means is you actually stand in agreement with it. It doesn't mean that you comprehend it. So when you go in court and the judge is asking you, well, do you understand the charges against you? No, sorry, Judge, I don't understand those charges because I'm objecting to the jurisdiction and my pleadings in the form of demur. But that's stuff we can learn along the way here by continually watching our shows. You'll get all this stuff. So I may end up kind of like starting over so that we get all of like due process of law and how that all works. And tonight what I'm going to go into is the 4th, 5th, and 6th Amendment, after I kind of put some of this stuff out there. So one term is property, okay? That which is peculiar or proper to any person, that which belongs exclusively to one. In the strict legal sense, an aggregate of rights which are guaranteed and protected by the government. Okay, let's go to that Declaration of Independence, these rights that are guaranteed. That's property, okay? Your rights are your property, and this is why it's your property, okay? We hold these truths to be this is the second paragraph of the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, okay? Created. And they are endowed by their Creator with certain unalienable rights. Okay? That's it right there. This is the property that Black's Law Dictionary is defining. These Creator-endowed unalienable rights. That among these, not all of them, but just among these Creator-endowed unalienable rights is life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men deriving their just powers from the consent of the governed. Okay? So, right there, that's your rights. That's your property. And anyone who deprives you of a right is actually trespassing upon your property and depriving you of a right. That's the common law. Now, I've posted American jurisprudence on that bills of rights, okay, are just that's plural, with more than one Bill of Rights out there, which is part of what I've been teaching. You know, the Magna Carta, the Declaration for the Necessity of Taking Up Arms. That's a really good read, and I believe that was actually the second episode that I went live on Kirk's Law Corner. So you can go back and watch that video. And I pretty much read that whole declaration. That is from July 6th of 1775. Now, that's part of our rights. That Second Amendment actually talks about the right to keep and bear arms. Well, do you know why we took up arms? Read that Declaration for the Necessity of Taking Up Arms, and you'll know why. And it was because they were trying and attempting to extend that admiralty jurisdiction back onto the land and force us under the tyranny, the same tyranny that we tried to get away from in 1215 with the Magna Carta. Okay, obviously it wasn't a muzzle of a gun, which is what I keep saying. It was a muzzle of a gun. I guess it was a sword. Okay, it was a sword put to King John's throat. Said, "You will sign this Magna Carta, or we're going to kill you and go out throughout the castle and kill the rest of your family and your whole bloodline, blah, blah, blah. We'll just take care of business right here, right now." Which I hate to say it, but I really wish they would have, because it probably would have put the word out that this tyranny must stop, and it must stop now. We'd probably be a lot better off today. But nonetheless, when reading through that one there, it talks about the despotism. It talks about the tyranny. It talks about depriving of us of the right to a trial by a jury. And this is in 1775. And that's why it's all part of, okay, there's 4 documents here that are all together. Okay, so you have the Declaration for the Necessity of Taking Up Arms, and there's a lot of stuff in there declared. And then we have the Virginia Declaration of Rights, June 29th, 1776. Then we have the Virginia Constitution, which was actually adopted by the rest of the states. At this time, they had declared themselves states. They were no longer colonies. It was the 13 United States of America. Okay? So, and then the Declaration of Independence. Now, when reading the Virginia Constitution, most of the wording in the Declaration of Independence is actually in the Virginia Constitution. So when reading that, you'll notice that, oh, wow, that's almost exactly what the Declaration of Independence says. And like I said, most all of the other states adopted all of this. Okay, these are declarations. The Declaration for Taking Up Arms, the Declaration of Rights. That's the Bills of Rights that American jurisprudence is talking about under constitutional law. Okay, so it would behoove us to actually read this stuff, to educate ourselves on what it actually says, because it's amazing what's actually written in these things. It's like the necessity of taking up arms. It tells a story in a declaration of what they were going through and what was going on. And if you think what's actually laid out here in the Declaration of Independence is everything that was going on, man, it's going to really open your eyes. And if you want to listen to my monotone voice read that, like I said, go back. It's the second video on Kirk's Law Corner. And you can hear me read it to you and explain it to you. You know, I went through it. I know a couple episodes ago I went through this Declaration of Independence and some of the things that we declared our independence from. And in actuality, these are declared acts of tyrants, of tyranny, not just the separation from the king, but these are declared acts known to tyrants. So read this stuff. That's what we're supposed to do, is we're supposed to read this stuff, because this is where ignorance of the law is no excuse. You're supposed to read the law. Statutes, rules, regulations are not law. Okay? Bills of rights are the common law. That's what we're supposed to know. So if you ever go into court and you go, well, judge, this is what it says. Because the sole duty for the judge is to judge facts of law. Yes or no? Is this a fact of law found in the Declaration of Independence? Is this a fact of law found in Black's Law Dictionary as it's defined by Black's Law Dictionary? Well, yes, sir, it is. Okay. That's the only job, the only duty that a judge has. So if you get in front of a judge who's acting outside of that specific duty, well, that's an usurpation of power. That's actually treason. But again, you have to know. You have to know what your rights are. You have to know how to effectively claim them and defend them. So when you go into court, you get your summons to appear, you have to know how to make an objection and bring forth your affirmative defenses, declaring, I don't consent to this jurisdiction. And here's why I don't consent to this jurisdiction. And then they have to prove that there is jurisdiction, because the burden of proof is on the moving party. So when somebody brings an action against you, you know, and Chris and Crystal both can attest to this, as soon as you file something against them or anyone else, automatic Rule 12B motion, boom, that is a motion for dismissal. It is exactly the same thing that we need to be doing. So if you don't know what the law says, there's no way that you're going to be able to effectively claim and defend your rights, because you don't know what it says. You haven't read it. And that's your duty and responsibility. Exercise your right to due process of law in a timely manner. You have to know this stuff. It's not hard. It's not hard to read. And some of this stuff I have memorized, because I've read it quite a few times. But you take this with you when you go to court. You take it with you. Take it with you everywhere. I mean, half the time I travel around with my Black's Law Dictionary and this right here with me. So if there's any problem, I just whip this stuff right out. Well, this is what it says.
You know, I'm going to interject something here real quick, Kirk, too, when it comes to court. This is what I always tell everybody. Make a bulleted, make a list, bullet point list of what's going to be talked about that day, right? Because when you have a hearing based on a motion or an action that was brought before the court, that's what they want to talk about. What's before the court? Excuse me, what that day. So that's where you can take what we're teaching you and shine with it. So you say, based on this, document that we have before us, this motion, okay, we want to take, and we believe this false statement should fall under the the fruit of the poisonous tree doctrine, or this should fall under the falsus in uno doctrine, and then explain why. But if you don't know what the falsus in uno doctrine or what the fruit of the poisonous tree doctrine is, the falsus in uno doctrine is based on testimony. The fruit of the poisonous tree doctrine is based on the rules of evidence. So that's one of the reasons why we do this. So you can take this knowledge and apply it to a specific piece of evidence or testimony that you want to challenge when you're standing in court before the judge. Okay. So when lawyer from Dewey, Cheatham and Howe says, on this date, this happened and the defendant was, did it. And you can, instead of standing up and blah, 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 that's bullshit, blah, 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 you say, no. Under the falsus in uno doctrine, I have a document here that was obtained legally that proves my time card that I was not at the place where the plaintiff says I am, or what says I was. So you can't be in two places at once. So what does that do to the credibility of their testimony? It completely crushes it. So that's why I say, you stick to what you're talking about before the court at that time. So you have to know what the falsus in uno doctrine is. You have to know what the fruit of the poisonous tree doctrine is. And the book even goes into defining what poison fruit is, how a specific piece of evidence becomes tainted, therefore not usable in court. So that's the stuff the judges want to hear from you. They want to hear not how smart you are. They want to hear why this thing that the prosecution or the plaintiff has brought before the court should not be before the court. And as long as you can do that and do it clearly, concisely, and, per the rules of the court, hey, you'll be fine. I mean, this is, if you have to use the underwear analogy, that one works pretty good. But, for the most part, it's keeping your head about you. And that's what we want you to do, is keep your head about you.
Right. So, and that comes with knowledge, because knowledge will give you power. Okay?
Right.
So, and this is what they will try to do. They will try to trip you up. They will try to get an emotional response out of you so that you look crazy. The second you freak out and start going off on them, you're done. They're not going to listen to a word you're saying. And, Ted had a show here the other day with Mary. It was in an EEOC federal civil rights judge. Okay. And I specifically asked her about this topic. What do you do as a judge when you get somebody comes in there who just starts going off? She don't listen to them, and she doesn't grant what they're asking for because of their attitude. So you can lose your whole entire case because of your attitude. Your paperwork can be immaculate, perfect, beautiful. Judge agrees with you. But you act like a jerk in court and start threatening the judge, you start threatening the prosecutor, you start threatening everybody else. Judge's going to throw your ass out, probably in handcuffs.
Probably.
Called contempt of court. That is actual contempt of court. So, yeah, it is about our attitude. So I'll be the first to say I had to change my tune. I wasn't always this calm. You think I'm not calm sometimes? Imagine what I was like a few years ago before I learned. You know what? My message is going to get across a lot better if I'm, more approachable and more presentable, and the way I present the information or going to court and talking to other people. And it all boils down to treat others as you want to be treated. And don't always assume that the judge is the bad guy, because there are some out there that are good. But here's the thing, and it's the most common argument. Well, they don't abide by it. They don't listen to it, blah, 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 blah. Of course they don't. They don't want to. But you have to file your paperwork. You have to create the record. You have to make your arguments in and on the record. Make your oral arguments. And I don't care what that first judge does. I don't care. They're an admiralty judge. They have no, this is how we're going to get rid of them, guys. Making your arguments properly with paperwork filed properly. And then when you go to the appellate court, and when you go to the federal court, yeah, I know. Oh, well, they don't do it either. Again, that first court you go into in federal court, more than likely that federal district judge isn't going to listen to you because they like to pass the buck. They don't want to be on the hook for saying, yeah, you're right. You're absolutely right. I see judicial notice here. I see that you're talking straight and what the law says. That's the rule of law. But again, forget what you've been in front of before, what you've been through before. The rule of law is coming back. This is what Trump said he was going to do, and it's happening. The Attorney General for the United States of America just came out with that. This is what's coming down the pipeline, folks. Rule of law. If you don't know what the law says, you're not going to receive justice. You're going to get railroaded. You're going to get screwed. It's just the way it is. And like I said, Trump put out well over 100 judges clear across the United States and instructed them to start upholding the rule of law. And start telling the rest of them they better start upholding the rule of law because they're going to get ousted. It's coming. Give it some time. But we got to do our part from the bottom. We can't expect Trump to do it all for us. You know how many people are attacking him for everything that he's trying to do? Yeah.
Got the whole system out after him.
What?
How you doing, Kirk?
How's it going, Brian?
Not bad. A couple of things. Now, correct me if I'm wrong. You said unalienable.
Mm-hmm.
Isn't it unalienable?
Yeah, but most people will try and not even quite understand that. Unalienable, you can't place a lien upon them. Unalienable, it just can't be bought, sold, traded, given away, taken away, except upon civil death.
Yeah. Now, the next thing you said, the leading case for the 12B6 is Trenzi versus Pagliaro.
No.
That case is
Trenzi versus Pagliaro is, while statements made by the attorney might be enlightening to the court, it is not admissible as evidence, blah, blah, blah. That's not a legal.
That is correct.
And that has nothing to do with the Rule 12B motion. Rule 12B motion is a federal rules of civil procedure for objecting to the jurisdiction.
Well, when you see the U.S. Code annotated and you see the federal regulations annotated and all that stuff, Trenzi versus Pagliaro is one of the annotations.
Right.
Why that's important is exactly what you just said. That they can't get a case dismissed or summary judgment because why? Attorneys do not have first-hand knowledge.
Right, but that's not what we're talking about on jurisdiction. We're talking about personal jurisdiction.
Yes, and it goes both ways. If they file a case against you, as use family court, for example, because I know you're. This
is what I'm trying to get at. Is I'm trying to inform people that this is what happens to us, which Chris and Crystal can both confirm that they got a Rule 12B motion filed against them when they filed their paperwork. And what I'm trying to tell the people is flip this around. This is due process of law. This is how they do it. This is exactly how we need to do it. So anytime that you're charged with something, this is exactly what you need to do.
What I'm getting at, jurisdiction. And you're right. What I'm getting at is when they try to assert jurisdiction through their unlawful process using statutes, codes, rules, and regulations, where some agent does something, we'll say, since they use it in family court a lot, an anonymous call, right? That means what? They're in court espousing information where that they have no first-hand knowledge of. Without first-hand knowledge, it's all hearsay, And they cannot, if you know the law and you know what you're doing, they cannot even get jurisdiction over you without firsthand knowledge.
Well, see, that goes back to due process of law, and I don't need Trinity versus Pagliaro to tell me that.
That's right.
And which I'll get into tonight with the 4th, 5th, and 6th Amendment to the Constitution. Specifically, the very first part, it doesn't matter whether it's criminal or civil in nature, okay? This is part of demanding to know the nature and cause of action, which is a word and phrase that I've informed people to look up and understand what cause of action is, because that was one of the most biggest epiphanies I've had in law in and of itself, dealing with court, is cause of action, okay? So the first thing is affidavit. This is the very first thing of due process of law. There must be an affidavit of truth signed under penalty of perjury, which carries a 5-year prison term if you lie on your affidavit. This is why it must be signed under penalty of perjury and notarized. This is the very first part of due process of law. If you go into court and you pull up your paperwork and that affidavit either doesn't have a name on it or there is no affidavit, guess what? There's a lack of personal jurisdiction, because what is the name of the man who is claiming a right to a cause of action here, which would give him standing to bring this cause of action. So standing comes after cause of action, or is part of it. But when you read the rules of procedure, lack of jurisdiction is for failure to state a cause of action for which relief can be granted. That's in the rules of procedure, those exact words. That's what it reads. So it doesn't say anything about standing, although that's what standing is the right to claim a right to a cause of action. There has to be an injured party claiming a trespass upon your property or their property and a deprivation of a right. Whether you caused injury or harm is what gives them the right to a cause of action. So if they don't have a right to a cause of action, there's no jurisdiction here. Period. Okay. Now, if you're being subjected to a jurisdiction that doesn't allow you to demand your right to a trial by a jury, guess what? That's a declared act of tyranny, in most cases depriving us of the right to a trial by a jury. Those fall under bills of attainder. Article 1, Section 9 and 10, both state and federal, are prohibited from making bills of attainder, which is legislation that describes punishment that deprives you of your right to due process of law. That's a bill of attainder. Bills of attainder penalties.
Of the of what Jeff Sessions just did is because he literally shut down those guidance documents, because that's a bill of attainder just with a different name. So because he shut those down, no more of this. Like the example that I used last week was Walmart corporate officer holding Target employee to Walmart policy. That's gone. That's done. No more of that. It's gone. So, rock and roll for us.
And if you go back into the old days, you're talking about King George and all that. I've said it to people before. The lords and dukes of the day were free men. Why were they free men? They knew the law.
Mm-hmm. Yep.
If you don't know the law, you're never going to be free.
Right.
And that's where the two forms of nobility come in, higher and lower. The higher forms of nobility know and can speak the law. The lower forms of nobility typically don't. So.
Yeah, an attorney, a bar attorney, British Accreditation Registry, registered with the Crown Temple Bar of England. They're given the title of nobility of Esquire. Happens to be the lowest title of nobility from the King of England, as an Esquire. And every attorney in the United States of America, around the world, have Esquire after their name. Think about that.
Which means they know their rules. You know, they can cite their rules all day, every day. Mm-hmm. Where they fall short is the law, right?
Yeah. Like you pointed that out right in the beginning. Their rules,
right.
Their statutes.
There it is, right there. Correct.
Statutes, rules, regulations, policies is not law. Has zero force and effect of law. Understand? It'll be a lot better.
I had a conversation with an appeal attorney, and I told her what I wanted done. Well, I don't know if I can do that. And it was my first and only argument with her. I told her, I said, you know, that is your problem. You were too busy worried about procedure that you can't even argue right and wrong. I said, she said, but I went to school for this. I said, you're right. You did. I said, but did you ever question why you only learned procedure, why you only looked at opinions of constitutional law? You never picked up the Constitution and Bill of Rights yourself and read it. And after that, she gave me respect after that.
Mm-hmm.
Yeah. I mean, it's just, I keep wanting to call it common sense, but, you know, reading the law and speaking the law. And then again, judges are there for you to ask questions of facts of law. This says that my rights are self-evident and they're creator endowed rights. Is that true, Your Honor? Yes, that is a true fact of law. Well, right, because that's what it says right here, and I'm reading it, and I'm putting this court on judicial notice that that's what it says. And the judge has to accept it, because that's what it says. And the Declaration of Independence is law. It's part of, and it falls under, the Ninth Amendment. Other rights retained by the people shall not be denied nor disparaged.
I can't tell you how many arguments I've had with the attorneys where they say that the Declaration of Independence is not law. Well, then my standard rebuttal question is, then why is it referred to as a founding document? Because if it's not referred to as a founding document, I mean, let's face it, they don't refer to the Magna Carta as a founding document. They refer to the Declaration of Independence, the Constitution, the Bill of Rights, etc. Those they refer to as our founding documents of our constitutional republic. So, you know, yes, the Magna Carta is related in history because, you know, one thing leads to another, and it's very fascinating history to research. But when you're actually presenting it in the court and you're actually asking the question in a comprehensive manner, okay, based on the law, based on this thing, all right, since I just did it, I mean, it's fresh in my mind. Since based on Article 1, Section 9, Clause 8, there's this word that has not been interpreted other than what its Black's Law Dictionary definition is. What does this mean and how does it apply in law? Because it's never been tested before. Because if you believe what the dictionary definition says, then that literally just wipes out everything that just happened. Is that true or false? And that's basically the question you got to ask them, you know, is with what this says. I mean, you know, I'm a person of at least average intelligence. Is this, because it's written in law, is this does this wipe out or cancel out that? And you ask the question. So, and that's where, I mean, I wish it were more complicated than that, but it's really just that simple.
It can't be complicated, or because the void for vagueness doctrine says it can't be complicated. Every law has to be written to where the common man or woman can understand it. If it is not written in that manner, then it is unconstitutional and unenforceable. That is a due process doctrine.
Correct.
So a lot of people cannot seem to fathom that it's this simple. It really is. That's why they don't want you to speak in court, because if you speak in court, it is your knowledge of the law that is applied, not
Correct.
The attorneys.
Right. And if you speak, they don't get paid. Right? Which sucks for them, but I mean, I look at it this way. Having gone down that road and paid and paid and paid and paid and gave them the chance to speak. I did. I was willing to pay for it. I did pay for it, as many of us have. And all these guys did was throw us under the bus. And it's like, well, now that it's, now that it's time to pay the check, now they're whining and crying and screaming and claiming, oh, you can't do that. Oh, really? That's not what the law says. So, that's basically where, we talk about the pendulum, how it swings back and forth. Well, it swung so far left and it's got so much force coming back to the right now. Anybody in the path of that sucker, dude, I feel sorry for him. I mean, just saying. But, and that's where we are. I mean, that pendulum's got some momentum going now. So, duck. That's the best thing. That's the best advice I could give any bad actor that ever pulled any crap over on a client at this point is, grab your little umbrella that Wile E. Coyote uses when the rock's about to fall on his head, because you got nothing better than that.
I got this one case I've been dealing with for about 5.5 years. I cannot keep an attorney.
Right.
One of the attorneys mysteriously died in his house. It's real. Now, that's another story. The weird people revolving around the case me and my family's been involved in. Mysterious deaths and a lot of people on the other side getting cancer all of a sudden. And hey, one woman that testified against us, nobody knew she had cancer. The very next summer, she was dead from pancreatic cancer. Yeah. 2 years later, my former public pretender mysteriously died in his house. You can't find out anything on how he died. He was found dead. One of the case workers that's still involved in the case, she developed cancer. I said, I do believe in God. My wife asked me one day when the first person died, said, do you think God's handling this? I hate to think that way. I said, honey, you mess with God's people, God will pass judgment. I said, it's not my place to say. That's between them and God. But I got this one attorney that he absolutely refuses to do anything I'm asking him to do. And his excuse is that I'm only retained for such and such matter. And he don't like me at all. And he's formerly an FBI agent. And he don't like it that I'm actually got Westlaw, and he don't like it that I've kind of got a decent knowledge of law.
That goes back to what Kirk was saying. They don't want you to speak the law.
You're not supposed to know the law.
That's your favorite story, Kirk. Let them have it.
You don't know the law. If you know the law, they can't pull the wool over your eyes. They can't tell you what it says because you know what it says.
Yep. They're trying their best to get me up there in their court, and I'm like, they don't have jurisdiction. The whole case is based on fraud. It's a void judgment, and a void judgment, you can simply ignore it because it's been void ab initio from the beginning. And when I start talking about the void judgment on the case, I've had attorneys that look at it and say, are you an attorney? I said, well, I subscribe to Westlaw. Does that count?
You know what my response is to that question? No, I'd never join the club. Sorry.
I told a judge that in Virginia when I beat a case. He said, you should be an attorney. I said, I couldn't do that. He said, why not? I said, because I couldn't do what I just did.
Right.
And laughed and said, "You're right."
Yep. I've had police officers. Are you an attorney? No, I'm just a lawyer. I'm just a knowledgeable person on the law. And yeah, I've even had public defenders and other attorneys say, "Man, you should go to law school." And I'm like, "Why? I already know this shit. Why do I need to go to law school to learn your statutory law? I don't need to go learn your fake law."
That's probably going away anyway. I mean, let's call that spade a spade. It's
Right.
going to be going away anyway. Why? Because, 80% or better of it is nothing more than an emoluments violation on its face.
Mm-hmm.
It's designed to give them an artificial advantage, right? There's that word again.
Artificial advantage.
Right. That is, that's why they don't want you to say the law. If you say the law, which is the thing that attacks their artificial advantage, well, now you're a threat, right? So, which my favorite response is, threat? Do you see a gun on me anywhere? And I'm really good at that, looking stupid. What gun? The better I get at that, the madder they get at me, and it just cracks me up. And it's like what Brian says, and by the way, your orders are not so much voidable as they are void. And if you don't believe that, go see Schumacher versus Schumacher.
Go see Marbury versus Madison.
Yeah.
That's the leading case from 1809.
Right.
Okay,
Yeah.
That's the leading case in history. Marbury versus Madison, 5, U.S. 137. Anything that comes in conflict with this, or anything that is repugnant to the supreme law of the land, is null and void from its inception, not from the day you go to court and brand it as unconstitutional. From its inception. Okay? So the birth certificate contract, that is void from its inception because it is fraud.
For that, I say choose your
selling
battles.
us our right, our birthright, and they're stealing it from us, and they're using the 14th Amendment against us, because that's what the 14th Amendment is about. It converted us all into slaves and granted us privileges and immunities. We no longer have creator endowed rights. At least that's what they tell us. You don't have creator endowed rights anymore. Your natural rights have, been acquired anew through civil rights. Well, there's a difference between a natural right and a civil right. A natural right comes from God, okay, as a creator endowed right as your property. Civil rights are created by constitutions. So, not bills of rights, constitutions, or statutorily. That is what brings about civil rights. Okay, so civil rights come from statutory law or constitutions. Okay, anything that is a creator endowed right from the law of nature, that's why they're called natural rights. Okay, they naturally belong to you. This is within nature. As you're walking down the road or walking down the trail out in the woods, okay, exercising your right to liberty, you have the right to be free from any kind of governmental interference. Statutes, rules, regulations, uninhibited by any statutes, rules, and regulations, okay? That's just the law of the land. That's just the way it is. Natural rights belong to us as property.
You also have to consider this stuff evolved over the last 200 and some years, because we had a problem that had far-reaching consequences, and Congress enacted this mechanism to deal with the problem. So when you talk about, like, for example, infrastructure projects, okay, that's typically the left's, favorite pet projects. they're all about the infrastructure, and that takes money to do that. And that's true. It does. The problem with it is, you know, you got into this situation where they had the unreasonable working conditions, which is what created the unions. Well, then the unions became too powerful and started to figure out how to litigate and lobby in Congress. You see what I'm saying? This is where knowing the history comes in. So, I mean, this didn't happen gradually. It goes back to what should you do, right? You know, like, for example, the summons says, if you don't reply within the prescribed time frame, you will be found, you know, guilty, or, you know, whatever it says. But
default judgment, or they'll send another warrant out for you to come get you.
Right, exactly. That's, you know, it doesn't say you should, it doesn't say you could, it doesn't say you might, it says you will, right? Versus the Constitution says, well, what should you do? In other words, use the brains God gave you, right? I mean, that's what it boils down to. Should you arrest somebody for an unlicensed practice of law? No, you shouldn't. Should you arrest somebody for trying to break a violent prisoner out of jail? Yeah, you should probably arrest that one. So you see what I'm saying? There are thresholds to, you know, what should you do? What shouldn't you do? And
right,
you know, it's just like you said, you hate to break it down to something called common sense, but I mean, you know, I don't know. That's why I said it's just like Stephen Fuchs said. One of my law professors said to me once, he says, you know, trying to define reasonableness is like trying to staple Jell-O to the wall. It's best analogy I've ever heard, because you really can't.
Right. So I'd like to get into actual law here. So the Fourth Amendment, I'm trying to actually pull up my treatise on arrest and false imprisonment. And the Fourth Amendment, okay? The Bill of Rights. This is from the Bill of Rights. And the Bill of Rights is actually is an article, in addition to, as an amendment to the Constitution. It is not just amendments to the Constitution. So it's actually here's the crazy part, the sixth article of the original Bill of Rights, which actually entailed 12. Okay. So the first two were not ratified. So we actually have 3 through 12. There are now 1 through 10 articles of amendments to the Bill of Rights. So the fourth article of Bill of Rights says unreasonable searches and seizures. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue, but upon probable cause, imagine that, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, so the right of the people, that means every single one of us, okay, have the right to be secure, free from any kind of use of threat, force, or violence against us, okay? That's secure. That's what secure means. Houses, papers, and effects, okay? Inside your home, that's your castle. You're the king of your castle. That's your law goes on your property. Your papers, imagine that. When you get pulled over by an officer, oh yeah? Papers, please. Papers, please. No, we're not in communist Russia or Germany or anything like that anymore, okay? We declared our independence from tyranny of pulling this over, and I don't care what case law is out there. I've read some Attorney General's opinions, and there's one out of Washington that wrote it quite well, that, yes, that's actually a false arrest when an officer pulls you over. Why? Because I'm going to get into that on this treatise on arrests and false imprisonment, because of the Fourth Amendment limits that. That's why they're bills of attainder. Statutorily, they're saying that they can pull you over and demand your picture ID, your driver's license, registration, and proof of insurance. The Fourth Amendment puts a clear limitation on that. And I'll add the 10th Amendment to that, because there is no authority to make an arrest without a warrant, unless it's for a felony, a breach of the peace that happens directly in front of you. And going back to the legal maxim, what I can't do in my person, I can't do through the agency of another. In other words, I can't delegate my authority to somebody else that I don't possess first. So if I can't pull you over out on the streets and the highways and demand your driver's license, registration, and proof of insurance at will, neither can anybody else. Because that's the law of the land. And in fact, this part here is the supreme law of the land. And Article 6 says anything in the Constitution or the laws of a state to the contrary are not withstanding. So I don't care what your statute says. Your statute is not law. You're supposed to codify the law. And going back to constitutional law, this is self-executing. This is a mandatory. This is part of due process of law. Okay, so you can't make statutory law because this is the law of the land or the supreme law of the land. I'm trying to find exactly where it says that. But that's what it says here in this treatise on arrest and false imprisonment, because there is no authority statutorily to make statutory law regarding these rights. Again, these are our property. We own these rights. These are unalienable or unalienable rights. They belong to us as property. Okay? Ours. Unalienable. And like it says here, even just the slightest infringement on your liberty is a wrong. So even the officer, you're walking down the street and the officer says, sit down over there. That's $10,000 right there. Right there. Under a tort claim under Title 42, Section 1983, that's $10,000. Just that one command to tell you to sit down. Unless he's got a warrant or he is in the, firsthand knowledge witness that you've committed some sort of felony directly in front of him. Okay. And that's the key. It has to be directly in front of them. Okay. So let's go back to government, and we, the people, are government. So your neighbor, let's say you're my neighbor, and one of my neighbors comes over and says, hey, I just saw so-and-so beating the crap out of his wife over there. Okay. You say that you saw that. Do I have the right to go over there and make an arrest? No, I don't, because I didn't see it. I have so-and-so telling me that they saw it. Okay. But no officer, you can't call the police and say so-and-so just beat the crap out of this person over here and claim that it happened when you don't have firsthand knowledge that it happened. And not only that, due process of law kicks in. Okay. You have to go get a warrant. And guess what? Somebody's got to sign that affidavit of truth in order for that officer to take the affidavit of truth to the prosecutor to get the warrant. If the prosecutor doesn't have that affidavit of truth signed under penalty of perjury, that's a deprivation of your right to due process of law right from the get-go. So that's a motion for dismissal for lack of jurisdiction, for failure to state a cause of action for which relief can be granted, because you deprived me of my right to due process of law. You're not following the law, because that's what it says right there. Shall not be violated. And no warrant shall issue but upon probable cause. That whole cause of action with an affidavit, okay, supported by oath or affirmation, because that's what it says. It says what it says, and it doesn't say what it doesn't say, okay? That's why you got to read this stuff. And particularly describing the place to be searched and the person or things to be seized. So we have assault and battery next door, okay? We got somebody that actually saw it, that's willing to file an affidavit. Great. So they go in and they try to knock on the door and say, hey, we're here to serve a warrant. We're here to and see, this is the other thing. The preferred method is supposed to be through summons. But in certain instances, and this is probably the part of the test that they're supposed to go through, is they're supposed to see if there's an actual necessity to take this person off the the streets and incarcerate them to keep the rest of the public safe. Okay, they don't just have an arbitrary thought of, I don't like this guy, I'm throwing him in jail and I'm going to require him to post bond. No, that's not due process of law. That's excessive bail and punishment. You're trying to incarcerate someone who doesn't deserve to be incarcerated until they're proven guilty, beyond a reasonable doubt, by all 12. Virginia Declaration of Rights, the right to a trial by jury, only by consent of all 12, unanimous consent, because that's what the Bill of Rights, the Virginia Declaration of Rights, says. That's your right to a trial by jury of 12, and you must be found guilty in a unanimous consent to finding you guilty. It doesn't say a unanimous consent to not find you not guilty. It says unanimous consent to find you guilty. That's how that right works. That's why it's called beyond a reasonable doubt. You have to convince all 12 of the jurors beyond a reasonable doubt that they are willing to consent to finding you guilty. That's how that right works. That's in law. That's what it says. In fact, I'll just grab it so you know that I can read it to you right here. No ifs, ands, or buts about it. Let's see. Is it like this one? Oh, that's necessity taking up arms. All right, here it is. Okay, Virginia Declaration of Rights, Section 8. That in all capital or criminal prosecutions, a man has a right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor, and to a speedy trial by an impartial jury of 12 men of his vicinage, without whose unanimous consent he cannot be found guilty, nor can he be compelled to give evidence against himself, that no man be deprived of his liberty except by the law of the land or the judgment of his peers. That's what it says. That's how your right to a trial by jury is supposed to work. That's the Virginia Declaration of Rights from June 12, 1776. And just so we're all aware, that is as the theoretical foundation of all government. That's what it says right here. I just read it to you. You got anything to add to that particular part there, Chris?
Well, yeah, I mean, I was, those things you're talking about, you got to remember, this is where this goes back to what I was saying about, how these things developed in history. And what you're talking about is actually 100% accurate. Where we end up with these conflicts is, for example, back in the 1700s, there were no automobiles, there were no roads, there were no school buses, there were no school zones. So we had to enact laws to protect children in school zones, right? And prevent people from passing school buses when they're stopped. When they're stopped, the lights are going, little stop sign comes out. People still do that. They still blow right by a school bus with the stop sign out. Happens every single freaking day. And, here's
the problem with that. There's no statutory authority to do that. Okay. None. Zero. Show me in the law where it says the legislature can make statutory law regarding your liberty.
It's in the preamble. The preamble clearly states, establish justice and ensure domestic tranquility. So there's got to be some give and take in there somewhere, right? Because if not, we end up with anarchy. So
no.
Well, see, hold on. Bullshit. I mean, I get where you're going.
Now, here's why it's bullshit. That same argument I get from so many freaking people. Well, that's anarchy. That's anarchy. No, because here's where the law still protects you.
That's the key word, protecting.
If you drive your automobile past a bus and you run over a child, is that not injury or harm to that child? Isn't that protected under the common law?
It is.
Yes, it most certainly is. So now you have a right to a cause of action under the common law where it belongs. Under just deprive that child of their life and their liberty. You caused injury or harm to that child. You're being sued at a suit at law.
Right.
Not at statutory law in this fake jurisdiction under bills of attainder.
Correct. Yeah. And that's where we're going with this. That's where they've crossed the line.
Right.
Because the purpose of law is not to punish. The purpose of law is to deter. Right. So when they establish this social control mechanism over top of the intended purpose of law, which is to deter crime, right? That's where they've crossed the threshold, right? At least based on my reading and research. So, yes, as far as I'm concerned, if, numbnuts blows by the school bus with the stop sign, out, whether he hits the kid or whether he doesn't hit the kid. If he doesn't hit the kid, you know what? Somebody's, just lived another day, but that still doesn't mean that dude should be allowed to keep going down the road.
Now, here's my solution for that. Chase the guy down and say, hey, look, dude, did you realize that you almost ran over some kids back there?
Mm-hmm.
Well, I don't know. I really didn't know that. Hey, just so you know, there's a big yellow bus there, and when the sign comes out and the lights flash, it would behoove you to stop because there's kids coming across there. And if you run over one of those kids, you're going to prison.
But and that's where the protection comes in, right? We have not just the right, we
already have the law there. If you run over that child, the law is already there for that. So it's not anarchy.
I get what you're talking about. I get what you're talking about, but you're not listening.
You can't make statutory law.
Is the protection of the mechanism of children in school zones, their right to be secure in their, their life, liberty, and their property.
Right.
And if we're forcing them to go to school, then they do, it's our job to make sure that they're safe there. Right. And as long as
this is the most common misconstrued thing is under the guise of safety and security, we get to do this. That's not how it works. And that's in law.
This is the difference. What you should do versus what you do, right? When we talk about use the brains God gave you,
right?
Based in law, the law says establish justice and ensure domestic tranquility. It doesn't say establish justice and institute social control. Right? So, okay, that's what they've done, right? By all these bills of attainder or guidance documents. I mean, call them whatever the hell you want, right? And, that's where we have to go back to, hey, look, what the hell should we be doing? Yes, we have to protect children. We're duty bound to do that. I mean, damn, that's why we all got together. Right. And if that means that we put forth a statute that says if you drive by a stopped school bus and you can do up to a year in jail for doing that, hell yeah, I would support that. Nope. Because that only protects your kid. It protects my kid.
Because that's a what if. That's a what if.
So basically,
falls out of the sky.
The deterrence factor there is if you don't drive by the school bus, look, the deterrence factor is there. If you don't drive by the school bus that's stopped, you don't have to worry about it. It's like my favorite line in Liar Liar where he picks up the phone and says, "Stop breaking the law, asshole." It's just that simple,
Okay, so here I'm gonna get into this because this is perfect right here, and this explains it perfect. Okay, the authority to this is the law of the land under this treaties on arrest and false imprisonment. The authority to arrest without warrant was rather limited and well defined at common law, okay? A law which has been made part of our constitutional law in the due process provisions. The common law rule on arrest is based on experience and common sense. As a general rule at common law, an arrest could not be made without a warrant. Thus, the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter in delivering an opinion of the Supreme Court of Michigan as follows. The law governing the case is elementary, except for a breach of the peace committed in his presence, or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony, a police officer has no authority to arrest without a warrant. Okay? The objective in this law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrest had to yield to the liberty of the citizen. The liberty of citizens is too sacred to be left to the arbitrary will of men. Everyone knows what felonies are. The most common felonies are murder, rape, kidnapping, sodomy, armed robbery, abortion, imagine that, pedophilia, treason, and arson, okay? A breach of the peace is also obvious and well known. Therefore, everyone's liberty was safe since all knew for what reason they could or could not be arrested. That's because the common law lays this all down, okay? But where is the safety in one's liberty if they are to be subject to every ordinance or law that the legislative bodies may choose to enact? Or if the law on arrest can be changed by statutes? Okay, that's questions. So let's answer that. By the Due Process Clause, the common law governs what the law on arrest is in this land, and where it exists, the most statutes, and where it exists, the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinances. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. The following is the material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that existed for hundreds of years on this matter. Okay, so there is no statutory authority to make law, statutory law, regarding certain aspects of the law, especially due process of law. Okay, and then where you have these rights that come from the common law, which are, bills of rights is the common law. So this Declaration of Rights is a bills of rights, and your right to due process and your right to a trial by jury and all those life, liberty, and parental rights and marital rights and all those kind of creator endowed rights are from the common law and protected by the common law. That's the subject matter jurisdiction. That is the actual jurisdiction, is the common law. That's the law that we go by, because we all live at the common law with our creator endowed rights. Okay, there is no statutory authority when it comes to creator endowed rights. Natural rights and civil rights have nothing to do with the establishment, support, or management of the government. Now, y'all understand that right there? Because that's a big.
That's not. That was never
what Chris was just saying. There is no legislative authority,
and that's not in dispute. Okay, what I'm talking about is our duty. Okay, which is also in law to protect those who can't protect themselves. Specifically, the subject is the children. For two reasons. Number one, they're not big enough. They're too little. Number two, they don't know enough yet. They haven't been taught. That's our job, which is kind of where this whole thing begins. So if we're going to, like I said, if we're going to make it requirement that they go to school and learn this stuff, we have that duty to protect them, which goes back to the simplicity of the argument of, if you don't blow by the school bus, you don't have to worry about potentially doing a year in jail. I mean,
no,
this is where
make that statutory law. There is no authority to. I just read it to you.
I understand what you're saying, Kirk, but I'm telling you,
there is no statutory authority. Period.
There's a difference between statutory authority and duty.
What you're actually arguing is, what if?
And no, I'm arguing the duty to deter the crime, prevent the crime from happening.
No, because we already know that running over a child is wrong, and that's protected under the
know that. You and I know that.
Is.
But
you can't do that.
Exactly.
You can't run over a child with your automobile, your bicycle, your motorcycle, your airplane. Whatever.
Right, but you're taking for granted that everybody knows that. You're taking for granted that everybody knows that.
Ignorance of the law is
not everybody knows that.
And you can't use the excuse that people don't know, so we have to create this statutory law. That's what's wrong. People don't understand. There's no authority to make statutory law.
Well, like I said, and we can and these things we back and forth on, and as far as I'm concerned, we can agree to disagree, and I'm okay with that. But the fact of the matter is I believe when it comes to, establishing justice and ensuring domestic tranquility as written in the preamble, not even talking about the Constitution. I'm talking about the preamble. That's our duty, right? Mm-hmm. The keepers of the protectors of the land, right? That's every one of us.
Ensure justice
for every one of us.
Quality.
Right. Watch over those kids, right? Mm-hmm. And whatever it takes to perform that duty to protect those kids, hey, guess what?
No.
You know what? I'm the first one to say, half of this crap is bullshit. And I'm the first one to agree with you on that.
Okay.
However, when it comes to school zones where there are children, there exceptions need to be made to protect those who can't protect themselves. So,
now wait a minute.
Correct.
You're coming into the case
a small area where there's kids.
The kids have to protect themselves. No. You see, this is why we hire teachers. This is why we hire principals. This is why we hire the staff to run the school to protect our children. Okay, that's their duty, is to protect the child. Okay,
then we should arm them based on what's going on around the country today, school shootings and that. Then we should arm those teachers if you want to go down that road. But
that's what the Second Amendment's there for, right?
Well,
why should we deny anyone at any time the right to keep and bear arms? Because what is that right for? Self-defense. Not only the Second Amendment, especially, is so that we can protect ourselves from tyranny, that same despotism.
Correct.
And there's that admiralty jurisdiction back onto the land.
Right. That's and you just said it. The Second Amendment was to protect from tyranny, right? Yes. So by definition,
under the law of nature,
we shouldn't need guns in schools if every house around the school had one, because somebody around that school would take that sucker out. But like I said, but I could digress and do a Second Amendment argument all night long and have fun doing it. But the simple matter is, you know, dad kicks in and that's just where my brain goes. Right. I don't care if it's my kid, if it's the, you know, Joe's kid or whoever's kid, you know, I watch over all of them as if they are my kids. Why? Because as far as I'm concerned, they are all my kids.
Right.
Because that's my duty to make sure that their safety and their happiness are maintained. And if, for example, going back to the, you know, 20-mile-an-hour school zone or 15-mile-an-hour school zone, if that's what we have to establish to help protect those kids, you know what? I'll leave 30 seconds or 3 minutes earlier to get where I'm going if that's what it's going to take to make sure those kids are protected. You know what? I think I can sacrifice 3 minutes out of my day, you know? So,
right. But that goes back to common sense. But
there it is. Right.
What you're talking about when you're talking traffic,
what
should you do? In the Constitution is they have the right to regulate commerce.
Right.
Okay? Those acting in commerce need to have a driver's license as a professional driver. Okay?
School zones are not, we're not talking about commerce. And when we're talking about school zones, we're talking about protecting children. The intended purpose of
that local milk truck that brings milk and cold products to the school, big semi truck, that's a professional driver. He needs to make sure that he's not rolling through there faster than he should be so that he can stop if a child comes out in front of him. That's
even more so than that. That's why they schedule deliveries when the kids are in the classrooms. Common sense.
Right. I mean, that would make sense. But still back to the, you know, acting in commerce itself. Acting in commerce is what the driver's license is for, because you're supposed to be a professional driver. Okay. So you must act in a professional manner. And if you don't act in a professional manner, now they can give you tickets and give you points on your license. You get too many points on your license, you can no longer be a professional driver because you're not acting professionally. Okay. But the general population that are going to grandma's house, that are going to the grocery store, that are going to the school to pick up their kids are not acting in commerce. They're not professional drivers. Okay. They're not.
So no 5-point harnesses and, you know, race cars in the.
Whoops.
We lost him there. I'm not sure.
Yeah, I hit the wrong button.
Dope.
You're still there. Okay. Yeah. So, you know, this is all about commerce. Yes, you can license that, and those signs and the speed limit signs and all that apply to those people as professional drivers. Okay, back to the basic principles of law, common law, the law. Do no injury or harm to your fellow man. If you do, that's when you've created a crime, committed a crime. Okay, until then, there is no crime.
Absolutely. So in other words,
anyone sign an affidavit claiming a right to a cause of action, which gives them standing to bring an action against you.
So then let me go to court. What harm does it do to create a statute that deters the crime from happening to begin with? What harm does that do?
No, you don't need a statute. You should already know that running over.
There's your problem, Kirk. What you should know and
need a statute to tell us that.
And what they actually know is two different things.
It doesn't matter. Do you think the statute's going to actually change that same person?
If it protects and saves one life.
If you don't already know the law, how are they going to know the statute? So your argument
saves one life.
So, I mean, think about that.
Do your school zones have those little statute signs?
Well, no. But he doesn't know that it's unlawful to run over a child with his automobile.
Actually,
so here make a statute, so he will know.
Well,
if he doesn't know that that's unlawful now, how is the statute going to make him understand that that's unlawful?
Because here, I don't know about out there, but here in Florida, we do post statute signs, especially in school zones. according to Florida statute, blah, 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 blah. I don't know if you guys have those, but we do here.
But again, ignorance of the law is no excuse, and statutory law is not a law. It has zero force and effective law.
Well, that's the statute states the punishment if you break that law. So,
the statutory law is designed to codify the law, to provide a punishment for the law.
Exactly.
Of a right.
Exactly.
Law.
Right.
So, okay, what are you going to codify?
We're going to codify we're going to codify what happens when you blow by a school bus that's stopped with a little stop sign out.
Where in law does it say that blowing through a stop sign and going through a school bus is unlawful?
You would think that well, pick your it's not written in your state's constitution, I guarantee you, but it is written in your state statutes.
No. In law, statutory law is supposed to codify the law.
Right.
Where in law are you claiming that the law says you can't blow through a stop sign, you can't run by a school bus? Where does it say that?
Well, I'm not looking at the exact I'm not looking at the exact law right now. I'm telling you when we're talking about establishing justice and ensuring domestic tranquility, we need to have rules that codify, that validate, and provide.
Codify the law. So what law are you codifying?
All right. Like I said, if you want me to,
people think that it's under the guise of safety and security that we can do this and create a punishment, a bill of attainder.
No, I'm not talking about a bill of attainder. I'm talking about outlining specific punishments for that particular crime.
That's a bill of attainder. That's legislation that prescribes punishment.
No, it's not, because if every school bus has a camera, do they not? So when you drive by that school bus and the camera takes a snapshot of your driver's license, of your license plate that you blew by that school bus, right? When it was stopped, that's the witness that the officer needs to go get you and punish you for committing that crime. And I'm sorry, but I agree.
See, this is the problem we have. You say it's a crime. Show me the law that says it's a crime.
Child endangerment is a crime. Reckless endangerment.
What child got endangered? Where's the law that says that?
Well, I'm not going to pull up the Florida statute that says that right now. I'm going to tell you.
That's not, I said law. Constitution or Declaration, Bills of Rights, that's law. And you know damn well what I'm talking about.
I know what you're talking about, but you're splitting hairs now.
Common law.
You're splitting hairs.
Is not law.
If you want to go under the common law says you have no right to endanger another person, right?
No, it says injure or harm.
Well, injure or harm, but that means.
So where is the injury and where's the harm?
The injury, first of all, is if you do it, 10 other people behind you are going to believe they're going to be able to do it.
No,
next thing you know, a little stop sign on the side of that school bus doesn't mean jack shit.
Harm is a deprivation of right.
Haven't deterred anything.
So where is the injury? See, this is a problem we have, folks.
Right. The problem is
we have people that think this way.
There's no way to measure the success.
Like Abraham, was it Abraham or Benjamin, when asked, well, what do we have now? And he's like, we have a republic if you can keep it.
Right.
Okay?
So
we've been legislated to death.
Right. And you're talking about, at that time, you're talking about horses and buggies that could, you couldn't stop them on a dime, but they weren't going 60 miles an hour. I can tell you that right now. So,
yeah. Okay. But,
so, we're talking about
how often do you see an automobile traveling 60 miles an hour through a 20-mile-an-hour school zone?
It happens. Believe it or not, it happens all over the place.
Question: how often do you see that?
It happens every day here. It's all over the news every day. I mean,
we're talking somebody goes 60 miles an hour through a 20-mile-an-hour school zone.
It happens.
It's hard to believe when everybody else is doing 20. How are they not hitting cars and running over people?
Because when they start the school zone, when they start the blinking lights for the school zone, they start them 45 minutes before, and they go, I think, 20 or 30 minutes after the, that period. So people are going through there because they're not paying attention. They don't see the buses. They don't see the kids.
It's always done under the
so they're not paying attention to the light
people, and that's what this gets played on when there's actually no authority to make that statutory law, because you're supposed to be codifying the law.
I'm going to agree to disagree when it comes to protecting kids. I'm all about protecting the kids.
I totally understand, and I really feel for you, but it's not.
It is what it is.
There is no proper delegation of authority to make statutory law that says, if you do this, and that falls under bills of attainers, legislation, punishment, and they're prohibited. Article 1, Section 9 and 10 of the Constitution of the United States of America. So it's prohibited from the federal government, and it's prohibited from the states.
Well, if you want to talk about
statutory law that is legislation that prescribes a punishment for this act.
Well, if you want to go into that, you could go to the Declaration. The Declaration, basically defines what your duty is.
Mm-hmm.
Okay, so if you can basically reasonably articulate a duty, and that duty to protect your children, then there's a maxim of law that says what is necessary is legal. Protecting your children from a moron in the wheel that doesn't know how to freaking drive, you wouldn't think that's a duty, but guess what? It is a duty, especially here where you're talking about, here in Florida. Florida is an area it's not a rural town. I mean, we're talking major metropolitan area. It's very transient. We have, nationals and, people coming in from different countries. They drive on the wrong side of the road. They tell us we drive on the wrong side of the road. You're talking about people who do not have any concept of what we do here in America, visiting for the first time. So, where we're talking about a major metropolitan area where there's thousands of people and kids and schools right in the middle of all of that. Okay. Yeah. We have a much broader scope of duty to protect those kids from, elements that rural towns don't ever see. You guys don't ever see this stuff.
Do you remember this happening in
daily
Tampa?
Lives?
Remember how, for a month straight in Tampa, this was all over the radio. There was a car every other day for a month going the wrong way on the interstate.
Yeah,
It was
I remember
insanity. That was just a couple of years ago.
Yeah, I remember that. It was the strangest damn thing you ever saw. Come to find out, did you follow the story and find out who it was?
The thing is, there was
was it the same person?
It was different people. It was
different
some
people.
Old people, young people, men, women. There have been instances of people from out of town, because there are a lot of people who visit from around the world, and they bring their own set of rules from their own country and driving. It's pretty wacky there. I have to agree with Chris at that point, because they I have seen dead bodies on the side of the road in the morning. I've seen cars completely disintegrated from Mack trucks just going to work and back. It's if you're driving in Florida, you are taking your life in your own hands. I'm it is probably the most dangerous place to drive on the planet.
It's a different animal here, man.
Unless you can prove beyond a reasonable doubt to a jury of 12 to find this other man guilty by their consent that he caused injury or harm to you, you're screwed.
I missed half of that, Kirk. Say that again.
Okay. Unless you can prove injury or harm to yourself, to a jury of 12, of his peers, of his vicinage, and convince them to find him guilty of causing injury or harm to you, when you have no evidence to show that he did cause injury or harm to you, you're screwed. Because that's what the law says.
Right. So
beyond a reasonable doubt that he did cause injury or harm to you.
Well, all right.
But he did this. But he did that. Right. Where's the injury or harm to you?
Okay. Here, let's use Ted's example. The guy going the wrong way down the interstate. That stopped traffic for miles. People were late for work, getting written up. I mean, all kinds of havoc. It was ridiculous. It got to the point it was a joke, and bosses weren't believed because it was happening so frequently. The boss was going, "Oh, bullshit. That was last week. You're not going to tell me that happened today." Okay. And it did happen. And these people did get written up, and they did get, disciplinary actions or whatever. So when you're talking about the harm, okay, so I lost 2 hours of work because this jackhole was going the wrong way down the freaking freeway.
Now, remember, another element to jurisdiction is you have to prove that they willfully intended, mens rea, okay? They had willfully intended to deprive you of your right, to cause injury or harm to you, to make it a crime.
Well, again, was the person drunk?
No. That's irrelevant. Did they willfully intend to do this?
Nobody knows.
You have to prove that. You're the moving party. You're the one making the claim.
But you asked what the harm was.
If you prove that, then you don't have a case.
You asked what the harm was. We're not talking about the rest of this.
How to attack these cases
right
being brought against you without all of these elements of jurisdiction.
Right. So when you're asking what the harm was the how many miles of traffic and people that were late for work. That's the harm. I'm not
asking about the harm part anymore. We already passed that. I'm talking about mens rea. I'm talking about willfully intending to do that.
Well, I didn't follow any of those cases to find out, what their actual intention was.
Right now, let's say you were sitting in the traffic, and now you're going to take this guy to court, and you're going to say,
I would find out who he was.
He intended to do this. I know it. I know he did. Where's your evidence that he willfully intended to do it?
Well, the difference is I'm not just going to come out and make such a stupid claim until I know what's the guy's name? Was he drinking and driving? Was he a local? Was he, what happened?
Well, the law says alcohol is legal, so I don't understand drinking and driving. Unless you're acting under commerce and you have a professional driver's license, which that driver's license says that you can't drink and drive.
Well, okay? Yeah.
That's like saying you can't have the right to keep and bear arms. You can't have your arms while standing in a freedom of speech area.
Mm-hmm. I can tell you live in a very small town. You don't spend much time in the city, do you?
I live almost smack down right in the middle of downtown Boise.
Downtown Boise.
Mm-hmm.
How many people in Boise?
About 5. If you count the mayor.
Right. That's 6.
No, I mean, we're not huge, but, we're over 100,000.
Right. So, and this is why I say, and this is where it gets interesting, because you talk about the differences between geographics and demographics, and, where that goes into totality of circumstances, right? What was the totality of the circumstances on that day when this event happened, right?
Right.
So that's why
you still have all the elements of jurisdiction that you have.
All of these rules, all of these procedures, okay? And, willful intent, mens rea, or, mala in se versus mala prohibita, call it whatever you want. It's there needs to be, when you're talking about areas where there are lots of people, okay, there needs to be a certain way to keep things flowing the correct way. I mean, let's just call that spade a spade, because otherwise we end up with traffic jams and nobody gets anywhere. And it just gets freaking ugly. But You know, I mean, for the most part, people are decent about it. They really are. But, you know, every once in a while you got that jerk, right? That one guy or girl or whatever who, law doesn't apply to me. This doesn't apply to me. That doesn't apply to me. Well, it doesn't matter if that's your kid. You better treat it like it's your kid. Well, I don't have kids. Well, that's your bad. That kid is just as much your responsibility as it is mine, as it is anybody else's, to make sure that kid's safe. So, you know, this is why I said this is where reasonableness, totality of circumstances comes in. This is what you have to really maintain. And this is the reason that, you know, I don't mind living in a major metropolitan area. I like the city, but you know,
all of those
crap that goes with it, but
do not change the fact that there is no delegation of authority in the law for you to make statutory law.
There actually is. I'll dig into it. I don't have it right here in front of me now. If I'd have known we were going to get into this, I would have had it ready to go.
Come on, you're supposed to know this stuff. No,
hell, dude, there's no way in hell everybody
can know it. So again, what would be the law that you're actually codifying? Because there is none.
That's what I said. If I'd have known we were going to have this specific conversation, I'd have had all of that up on my screen. I guarantee.
Be ready for anything. Come on, now.
I would have. Oh, I would have.
But that's just how it is. That's, you know, understanding what our founding fathers went through, all of the despotism and the tyranny and everything that's listed in the Declaration of Independence as declared acts of tyranny. If you read that declaration for the necessity of taking up arms, you'll hear the story of what they were going through and the atrocities that were happening. Okay, so when you understand that, then maybe you'll understand what I'm saying is that you don't have the authority to create bills of attainder. You don't have the authority to create legislation that describes a punishment without a person that follows due process of law, affidavit of truth signed under penalty of perjury, claiming a right to a cause of action, having standing to bring this action against me. Okay, and then we're going to talk about the subject matter. Are we in the proper court, having competent subject matter jurisdiction? Okay, all of those things that are by law have to happen. But if you don't know that stuff, you can't object to it. You don't know how to object to it if you don't read the rules of procedure.
That's correct. And
so you have to know the law first. You have to know what your rights are. Then you have to know what the rules of procedure are to effectively defend your rights.
And there's your answer. Nobody defends anything anymore. All everybody wants to do is prosecute. And that's a problem. When everybody turned to prosecution, you know, we're right back to those same atrocities and despotisms. You know, you see it over the news here every night. You know, cops going and kicking in a door. You never know what the hell was actually going on there that they went and, you know, SWAT actually surrounded that house and kicked in that door. You never get that part. All you get is the aftermath that's on the news and what they claim, right? Their statement of claim on the news. You don't actually get what actually happened. So,
yeah. So, Brian, my friend Brian Carter on here, 664,422. That's in our metropolitan area, Boise, Nampa, Caldwell, our metropolitan city here. We're starting to turn into a metropolitan city because they're all joining together. I mean, you got downtown Boise, Garden City, and then you got Meridian, Middleton, Eagle, Middleton, Star, Nampa, Caldwell. I mean, out south we got Cuna, and it's all part of backside of Nampa, Caldwell out there. But this big general area, I guess we're right around almost 700,000 people. So I mean, it's not like we got 5 people that live here,
right?
And it's not like we're still on horses and wagons like back in Pennsylvania,
right?
The Amish. And I've been back there. I lived there for about 3 months. Oh. So I know what it's like in Harrisburg, Pennsylvania to see the Amish.
I was born and raised in northeastern Ohio, bro. I get it.
Oh. Let me tell you, a horse can kill you just as good as an automobile can. But one faster. Thing, an automobile can stop faster than the horse can.
Yeah, well,
that's a proven fact.
Yeah, remember, I was born and raised in northeastern Ohio. We used to go out to, Amish country and stuff like that, to the, all the different, what do you call them? Not fruit stands, one of those farmers markets, and to get our produce. When I was little, I remember doing that when I was little.
Yeah,
and that was that was kind of a highlight of the week, being that little. But the comparison and contrast from that versus where I am now, back there's no need for half of the crap that we do here in Florida. So, following the maxim of law, what is necessary is legal. So it's not necessary.
Well, you can have your legal maxim all you want, but the law dictates that you can't. So which one supersedes which?
There it is. And it's case specific.
Your legal maxim only goes so far as to the extent of the law.
And it's case specific. So, and it should be case specific. That was the intention of what we're doing here. Everybody has the right to due process of law.
It would not be case specific.
Sure it is. You take the same example we were just talking about from a major metropolitan city like Orlando or Tampa or somewhere like that. You cannot reasonably apply that to Harrisburg, Pennsylvania, for example, because there's just, it's apples and oranges, man. There's no need for that stuff up there.
Yeah, I've lived in both kinds of situations. I've lived in downtown Vancouver, Washington, which is right across the bridge from Portland. Both Vancouver and Portland back then were still rather large compared to Boise today.
Right.
I live in Podunk, Boise, Idaho now, but it's grown quite a bit since I was a kid.
Right.
And I lived in Vancouver there for about 7 years.
Yeah, and I think I do agree with
that. I still lived on the outskirts. I lived in the city for a little while, and then we moved to the outskirts and lived on a farm. We had a nice full-size pool. We raised pigs. We raised chickens. We raised rabbits.
So when I talk about the different geographics and demographics, you understand what I'm talking about.
Right. But the law doesn't change.
Well,
it's always consistent.
Yes, it does.
The same.
That's the reason each state is.
My right to life, liberty.
That's one of the arguments that doesn't change. The state, we're sovereign based on our traditions and our history. And, Utah's different because it's primarily Mormon than Texas, which is primarily something else, versus Louisiana, which is primarily something else, and so on and so forth. So
that's why we have the supreme law of the land.
Well, and that's the minimum standard.
Specifically says anything in the Constitution and the laws in a state to the contrary are not withstanding. That's the reason why we have the supreme law, and that's why we're supposed to be united.
Correct.
States. Not the United States. We're united states that have united under this supreme law.
Correct.
Under this ideology.
Right.
And that's exactly what it is. It's an ideology.
Right.
It's a religious ideology, and that ideology happens to be Christianity.
Well, Judaism.
Here's the Declaration of Rights. I'll read that to you. Section 16, that religion or the duty which we owe to our Creator and the manner of discharging it can be directed only by reason and conviction, not by force and violence, and therefore all men are equally entitled to the free exercise of religion according to the dictates of conscience, and that it is the mutual duty of all to practice Christian forbearance, love, charity towards each other. Now let me explain this real quick. Okay, understanding our founding fathers, and they thought, okay, we want to separate for religious reasons. We want to be able to practice our religion how we see fit, but we want our fellow man to be free as well. So what we're going to say is, you don't have to go to church on Sundays. You don't have to read the Bible. You don't have to do anything. Okay? The only thing we're going to ask you to do is you treat one another based on these principles, the 10 Commandments, and the principles laid out in the Bible of how to treat one another.
Correct.
You don't have to go to church. You don't have to be religious at all. But you have to treat one another this way.
Right.
Okay? Now,
the Lord's Prayer.
Even though all of our documents are signed in the year of our Lord, so there's more evidence that we were, still to this day, you read the executive orders in the year of our Lord.
Right. Exactly.
And Jesus Christ is the only man that's known to mankind around the world that we base our timeline off of. Think about that.
Right.
BC and AD.
Right. So which goes back to another thing you're talking about. One of the things that you see in pleadings is a prayer for relief. Right.
Exactly. Right.
Okay. So exactly.
Yeah. When you're seeking relief, you're praying to the judge.
Correct.
You're praying to the judge. Prayer for relief. That's in your order.
Right. You're praying that he sees through God the same thing that you see to grant your relief based on blah, 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 blah. And, it's ironically, speaking of things that have become moot, judges, half of them don't even go to church on Sunday anymore. If they couldn't recite the Lord's Prayer, if their life depended on it. So, and that's kind of a problem. That's a cultural issue, and
what you talking about, Willis?
So, hey,
cultural what?
I didn't say.
I'm reading some of the comments here. Oh yeah, I grew up in the country, farmers. It's a great experience, a childhood experience, because it teaches you responsibility when you have to get up at 3 o'clock in the morning.
Oh God!
You have to get out there and feed the animals. And in our family, we had the rule that if you forgot to feed the animals, guess what? Well, you forgot to get fed for dinner after school. You went without dinner.
Yep.
So you know how the animals felt when you forgot to feed them in the morning. Yep. Let me tell you, it only took about one time
for that to happen.
Forgetting to feed the animals.
Yeah. We're sleeping in.
Yeah. Well, that was it right there. For me, it was, oh, crap, I slept in. I didn't have time to feed the animals.
Yeah.
So from then on, I made dang sure that I got my butt out of bed before the sun got up and got out there and fed them animals before I had to go to school.
Right.
Because if not, I was going to be a hungry kid overnight. Nowadays, got to be an automatic CPS come kicking in the door. Oh, you neglected to feed your child.
Yeah.
And things are so different today than they were back in the 70s and 80s.
Man, dude.
For you, 60s and 70s.
Drinking from the garden hose,
Yeah, we used to drink from the garden hose. Right?
Yep. Yeah. We used to have the pump well in the backyard.
Yeah. We had the well. Mm-hmm. We also had septic sewer. We didn't have connected to city sewer.
Oh no, we had city sewage and stuff, but in my granddad's house, he used to love the well water, and I'm here to tell you that's the best water you'll ever drink. Is the water from Grandpa's well. I don't care what kind of water I can buy. Nothing tastes like anything like Grandpa's well did. And, oh man,
that is such good water. Because you're talking naturally filtered by the ground.
Yep.
Now here is a perfect example of a statute that works great. you can't have your well within 300 yards or 300 feet, 300 feet or 100 feet
300 feet
of your septic system.
Correct.
Why? Because, well, that drainage is going to run down into your aquifer.
Right.
Hello, back to, you know, the 1600s there with the plague.
Yep.
Okay. I don't know if that's Brian trying to come back on. We're about done here for the night, but
yeah.
You know, that is a legitimate one to protect the safety of yourself, of the people.
Right.
Not like the seatbelt law.
Oh, don't even get me started on that seatbelt law. I'll go off on a tangent that, those lying, thieving mother.
That's a bill of attainder. That's a law that prescribes legislation that prescribes punishment if you don't.
Have a peeve.
That's a perfect example of a bill of attainder.
I have such a peeve about the driver, about the seatbelt law, like you'll never believe. Ooh, I hate that seatbelt law. You know, the first damn thing that they said when they passed that seatbelt law was, we will never be able to pull you over for a seatbelt violation. They swore up and down that that's the way it's going to be. What do we have now every holiday? Click it or ticket. You lying mother. Don't, like I said, just, I'm stopping. I'm going to shut up.
Right. So, yeah, we kind of burned through some time tonight. I don't know who. Somebody's called in here. 304 6397. Let's go ahead and see who are we talking to.
My name is Mark Hallburn.
Hi, Mark.
Hey, Mark, what's going on, buddy?
Well, I'm a single father that's fighting the system, and I saw you show up on Facebook on somebody else's page, and you were live, and I thought I'd listen in and find out what you're doing and talk to you. And I don't know if you remember several years ago, there was a family court judge in West Virginia that was screaming at a preacher, and the video went viral and was on Fox News, and we ended his career. I was the guy that put that online, and so I have an interest in cleaning up family law.
Welcome aboard, my brother. Welcome aboard. That's what we're here for.
Right.
One of the things we're here for.
Yeah, one of the things. Tonight's actually we're starting to change our format. So Monday nights is going to be just Law for Dummies, where we teach the law. We're going to read the law. We're going to read it to you. We're going to teach you how to use it and all that kind of good stuff. On Wednesdays, we're going to do the call-in show. Now, on Mondays like tonight, we would do, you know, if somebody has a question, I kind of almost prefer to be in the feed here. And I kind of been trying to watch it, but like 4 times now, my phone has just shut itself off. Facebook has shut itself off while I'm trying.
Oh, I know. Mine did too. Half an hour.
I've had various problems with my phone.
Yeah.
But Wednesday nights are going to be the call-in show. Same time, 6 to 8 p.m. Mountain Time and 8 to 10 Eastern Time.
So anyway, what was your question, Mark, just for giggles?
Well, I'm wondering how it is that you get the family court system to honor the Constitution.
And that's
do we just have to go to federal court and file there and bypass the regional and county family courts?
Well,
okay,
it's funny you
bring that up real quick first, Chris.
Get into is you go ahead and explain it, Kirk. Admiralty jurisdiction, because that's your thing.
Right. So October 24th, I went down to my Idaho Supreme Court, and I sat in on an appeals hearing. 3 judges up there, and the very first thing I noticed was there was no gold fringe on that American flag. Okay. Marine Corps veteran, I can tell you right now, the gold fringe on the flag is Admiralty jurisdiction. So the first court you go into, if you walk in there and you see gold fringe on that flag, see this flag here? It ain't got no gold fringe on it. The flag that's outside doesn't have any gold fringe on it. But when you walk into the courtroom, the first court you go into, whether it's criminal court, civil court, family court, probate court, They're all admiralty courts. They're under admiralty jurisdiction, imposing maritime law, the law of contracts, your birth certificate, your driver's license, your social security card, your business license, all of those licenses that you're seeking permission from the government. And what that actually does is it binds you to these admiralty court jurisdictions. It creates statutory law. Okay. So, what's wrong, mouse? Go ahead and add your part there, Chris.
Well, to get back to his question, it is the one thing that unfortunately these admiralty jurisdiction or equity courts, okay, because that's actually what they are.
No. They are not equity courts.
Well, let's get back to it.
Enforcing maritime law, the law of contract.
Agreed. I get it.
This is a big misconception.
Hold on.
No. Because if you're going to put something out here, you got to put it out correctly. And what the law says.
Okay? We're talking about family court. Okay.
Right. That's not an equity court.
Family court.
Equity does estate, real estate, real property. This is maritime law under the marriage contract.
Which is one of our problems. They tried to take
jurisdiction is not equity.
You didn't let me get to that point.
Law and suits of equity.
You didn't let me get to that point. Okay, I'm trying to explain that. So they took a court of equity and tried to call it a court of law. They took these two fictitious decks of cards, shuffled them together, and created this thing called a family court.
No.
And basically its intended purpose was to, back when this whole thing was created, when the mom was a stay-at-home mom and she raised the kids and dad worked all day and provided for the family. The intended purpose was when that relationship dissolved, that the children would still be provided for. And, that was a way to equalize, right? Keep it fair. And what they've evolved into, or should I say devolved into, is they've changed the meaning of that equity, meaning equality, into equity, meaning money, right? Same word, two different meanings. So when we crossed that threshold, that's when we started to go, that's when we got into serious trouble. So, again, because this all happened gradually, oh yes, it's all in good faith. Oh yes, it's all in the best interest of the kids. It's well intended, right? Well, what do we know about the road to hell? The road to hell was paved with good intentions. So that's exactly what they did. They've repaved this road to hell with their quote unquote good intentions to maintain equality, right? So mom could maintain custody of the kids, and they could keep their little white picket fence thing, whatever the hell that was going on at the time. I don't know how old you are, so I don't know how much of this history but
okay, so actually it's actually maritime law, the law of contracts. The contract is actually the marriage contract. Now, under contract law in admiralty jurisdiction, administrative law, they create this statutory jurisdiction because of the contract under maritime law. This marriage contract, through statutes, they create administrative law.
Right. Well, you're going too far back.
No. This is how it is. This is why they did the admiralty jurisdiction.
They created the marriage contract. Right.
This is how it is.
Yeah, that's how you're talking about the mechanism they used to create the marriage contract, right? License it, which is, enter into this contract that, under maritime law, blah, 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 blah. That's how they created it, right? So when they figured they have to administrative, right?
Okay? That's what administrative law does. That's admiralty jurisdiction, administrative law, dealing with the maritime contracts.
Right.
Okay. So the contract again is the marriage license. That's the
correct.
That's right. The same thing with your driver's license is the contract.
Right.
Your social security card, that's the contract. Your business license, that's the contract. This is all under maritime law.
Right.
It is handled in admiralty jurisdiction. That's the fringe on the flag. It's not an equity court. They abolished suits at law and suits in equity because that's estate, real estate, real property. So again, this is under maritime law, the law of contracts.
Right. And why they're using
administrative jurisdiction, which is admiralty jurisdiction.
Right. Which is why when you walk into family court
of the legislature.
Right. And I'm getting to that. Right. And I'm getting to that.
Nothing to do with equity.
I'm getting to that. Again.
No, I already heard what you said.
Chris. No, you keep cutting me off.
I'm trying to tell you.
When you walk into the family court and the family court's got the admiralty fringe on it.
Imagine that. So you're in an admiralty court. You're not in an equity court. You're in an admiralty jurisdiction under maritime law.
Based on the marriage contract, which is a fictitious contract to begin with.
It's fraud. Marriage, marital rights, and parental rights come from the common law. They are creator endowed rights.
And that's one of my favorite things. I don't know this, but I found my receipt from when I paid for my my marriage license, and I actually showed it to the judge. Said, "Can I get my money back for this?" So,
yeah, they have it.
Who is that?
I'm not sure.
I don't know.
I know Neely is on the phone. People have been saying in the
comments. But everybody's muted.
Sorry guys. I was having to answer another phone, but I'm off. So.
Oh, hey Neely, what's happening?
Hey, nothing. I'm at work. I'm at work. Yeah, I'm at work. My boss just came in, and I was like, I gotta listen to this. And so leave me alone, basically. But anyways, I just wanted to touch on something. When I was witnessing, because I had to represent myself during a lot of the family court trial that I was being put through, and when I had the grandmother on the witness stand. This is a huge problem. I said to her, one of my questions was, okay, then tell me what the Lord's greatest commandment is. Because, I was basically trying to get the point across that I was trying to get
Okay.
Are y'all?
I'm playing with buttons here because it said everybody was muted, but yet you were still able to talk. So I'm trying to understand why you're still able to talk. But you're unmuted. Keep going.
Okay, so I just basically I had her on the stand, and this was the whole problem, is because she was harming my daughter, and they took my daughter away from me because of what I believed. I really truly was thinking that at this point. So when I had her on the stand, I said, okay, if you're a Christian, because she looked at me and she said on the stand, oh, I work at the Bible study. I'm a Bible study teacher. I said, okay. So I said, you have the responsibility to take care of a lot of children, correct? And she said, yes. I said, okay, then you tell me what the Lord's greatest commandment is. Well, everybody that is a real Christian should know that the Lord's greatest commandment is love the Lord with all your heart, all your mind, and all your soul. And she said, oh, respect your mother and thou shalt respect your mother and your father. I said, no. I said, you're wrong. So I just proved
that's actually in the 10 Commandments, by the way.
Would say that again?
That's actually in the 10 Commandments.
Exactly. The 10
Respect
Commandments.
thy mother and thy father.
But my question was, what is the Lord's greatest commandment? There's a difference. There's the 10 Commandments. But there in Scripture it says there is what is the Lord's greatest commandment, and it's totally different than what the 10 Commandments is. And the Lord's greatest commandment is love the Lord. You love your God with all your heart, all your mind, and all your soul. That comes first.
Where does that say that in the Ten Commandments?
It is. It's just the Lord's greatest the greatest commandment. I don't know necessarily if it's in the Ten Commandments. I don't know.
But so it is.
This is part of, you know, even though I'm a Christian man, okay, I understand what the founders meant by religious freedom. Okay.
Mm-hmm.
So, we have the right to practice our religion how we see fit, but we don't have the right to force that onto others, because that's what the founders were looking at. It's like, look, we want to separate for religious reasons and away from tyranny, but we also want to protect our fellow man because we do love our fellow man. Okay, so how do we do this so that we protect our rights to practice our religion how we see fit, and yet allow those who don't want to and still have the same rights and protect our rights, and to keep those rights protected from tyranny, from tyrants? Oh, well, let's do it this way. We'll say creator endowed rights, even though the Declaration of Independence specifically says God and nature's God. And all throughout history, we talk about God and a religious separation from tyranny, from the King of England, all of that good stuff. This is stuff that they argued about. Okay, the founders sat down, they tried to figure this all out so that everybody was happy, but yet everybody still had their rights protected and away from man, so that no man could take those rights away. Your right to life, liberty, and pursuit of happiness is a creator endowed right. That's why it's written in the Declaration of Independence for a reason, so that no man can make statutory law regarding those rights. That's the common law. And that, my friends, is why we have the First Amendment that says we have the right to practice religion how we see fit, but it doesn't say you have the right to be free from religion, because we still have to have some sort of ideology here and how we treat one another. And then again, we have to have the belief in God so that we have these rights. Because the second we lose that, that's how we end up where we're at today. It's because people have pushed that religion and that ideology away simply because, well, I don't want to be religious. But nobody seems to read history and understand they understood this. These people weren't dumb frickin' people, man. They were smart frickin' people. I don't care if it was 1700. You know, they may not have had the technological or the industrial advancements that we have today, but they were still very, very intelligent and very smart people. They were able to sit down and think things through, you know, and this all comes back to the argument of the Second Amendment. You know, people say, oh, well, they didn't even have guns back then. How would they even know what it was going to be like? Come on, people. If you read some of the stuff, man, if you could just sit down and read this stuff, you would understand why they declared the necessity for taking up arms, because they were tired of this tyranny being reimposed and reimposed and reimposed upon them. And it's right back to where we're at now, except for we've waited way too long to try and do something about it. So now it's going to be a hairy situation. Now, thankfully, we have somewhat of a chance where we have our president that is an actual de jure president, okay, doing something from the top. And again, back to us doing something from the bottom. And it starts with filing your paperwork. It starts with getting a hold of your representatives. Start reading them. Start reading to them. Figure out what's something that's bad in your state. Look at your Constitution. Look at the federal Constitution, the Constitution of America, the Declaration of Independence. You read all through all that. Then you look at your statute and go, wait a minute. Now keep in mind, Statutory law is not law. It has zero force and effect as law because it is supposed to codify the law. This right here. And if it doesn't do that, then it falls under bills of attainers. It is legislation that prescribes punishment. That is unlawful. It is prohibited in the Constitution of the United States of America. Article 1, Section 9 and 10. Understand, and I mean it, understand. Stand under the law, rule of law, what it says. And what it says is, that's prohibited. If it's prohibited, then you need to bring that to the attention of your legislators and say, look, here's the law. This is what it says here. This is prohibited, okay? But here's the statute that's is repugnant to the law. So somebody has usurped their power. It's an usurpation of power and has acted arbitrarily and it's an attempt to deprive me of my right. So this needs to be abolished, as in all political power is inherent in the people, and we have the right to alter, reform, or abolish anything at any time. That's our right. That's our political right. So long as you're an American citizen, you have that political right. If foreign people and aliens do not have political rights like Americans do. So that's one difference between the rest. Though the rest of them, the basic human being rights, everybody has those rights in America. And another thing is everyone around the world is looking at us to get this fixed because everybody goes off of our Constitution. Everyone goes off of our law. We have set the example for so long around the world that everybody follows. Now, I wouldn't say everybody, but most of the civilized nations and countries
Western
follow our rule of law.
Talking about Western civilization.
Well, what about Europe? What about Australia?
Well, I'm talking Western civilization.
That's not Western, is it?
No, it's derived and conceived.
I mean, are you talking flat Earth from the West, right? Or because when we're talking globe, there isn't really an East and West there.
Right. That's why I said, we're talking about who our allies are, for example.
Right.
Russia.
But I'm saying around the world,
back.
You can call it Western civilization. That's our law. That's what we go by. Our Constitution. That's why we are a constitutional republic. We are not a democracy. Nowhere in the Constitution, nowhere in any declaration that I have read says even the word democracy. Nowhere. Not even the Articles of Confederation. Nowhere in the Declaration of Independence. Nowhere in any bills of rights have I seen the word democracy, because we are not a democracy.
The Federalist Papers refer to democracy.
No, democratically.
We're right. And they also refer to the dangers of democracy, right?
Right. But I'm referring to as in our form of government is not democracy.
Right. I was just making a historical reference. That's all.
Right. But I'm talking about in our law stuff. So there's no confusion. And like this quote is attributed to Benjamin Franklin, but supposedly hasn't been fully found to be true. But it's democracy is two wolves and a lamb deciding what to have or voting on what to have for dinner.
Right.
A republic is a well-armed lamb objecting to the vote. And that's exactly what we are. We are a republic who is supposed to be armed and self-governed. Okay? We say what the law is. Well, they don't recognize that. I don't care if they recognize that or not. Speak the law, because that's what it says. And you appeal it, and you go to federal court, and of course, you're going into the district court, the first one. The very first one again, you're going to have to go up. So you keep going up the chain of command until you get the answers that you're looking for. So on that note, you got anything to add?
No, I'm good. I'm looking forward to federal district court. Services went out today, and you know, so as soon as those are done, I'll be posting in the group as to keep people informed as what's going on. But emoluments, the first federal emoluments prosecution, for example, for lack of a better expression, has been filed and is on its way to being served. First time in history.
Awesome. I can't wait for the first one. First one gets adjudicated, the heads are going to roll. Let's put it that way. I was going to say the balls are going to roll, but you know what I mean.
So it's going to be a fun one.
It is. I want to say thank you to all you folks that tuned in tonight for sharing. Like and follow Kirk's Law Corner if you enjoyed the show tonight. Now, we're going to be going live on Wednesday nights. We're going to be doing the call-in show on that night. So Monday nights is going to be Law for Dummies. We're going to talk law. Chris Howland and I are going to argue like we did tonight. We're going to argue back and forth. So you can get an idea how to make your arguments based on our arguments. How to argue your points of authority. My points of authority come from law. Chris didn't manage to pull up the law tonight because he wasn't prepared for that. So I wasn't either. I didn't know where that conversation was going to go, but I just, you know. I love you, Chris. I love you, Ted. Thank you for doing
what you love you too, Kirk.
Love you too, bro.
Thank you guys, everybody, for joining. It's a pleasure. We enjoy this, and we're going to keep doing it.
I hope you enjoyed it as much as we do, because we really do enjoy this. And then we have
we do
after show, and we laugh some more. So hopefully, oh yeah, Ted, did you pull up those little pictures, kind of give an idea of something for Wednesday, or did you not get that?
It's yeah, I made something up. I'm not sure if I'm totally into it, but it's kind of funny. There it is.
Yeah. Well, we'll have to roll with it and see. I liked it. The pictures that we picked out there, Chris picked out.
You should be able to
6 p.m. Mountain Standard Time, Wednesday night.
You should be able to see it on the screen now.
There it is.
What do you think? That's pretty hilarious.
Thank you, Brenda, Brian, John, Candy Connor. She's a new one. There's quite a few different people that I noticed on here tonight. In between my phone shutting itself, or Facebook shutting itself off. So we do want to thank you folks for joining us. Like and share, follow, and share Kirk's Law Corner. The March Us. Let's put the word out. That's what we're here for. We're doing our part. Share it so we can get it out.
Awesome. Thank you so much, Kirk. Thank you, Chris.
Thank you, Ted. Thank you, Kirk.
You bet, brothers.
Good night, everybody.
Yes.